Salutations to all our future judges. In this video, we are going to see Indian Evidence Act 1872. But before going into the video, I'd like to make few requests to our viewers as well as the subscribers. Kindly do not skip the video. Watch the video from the beginning till the end. If you skip in between, you may be missing very crucial information or very crucial aspects which have been explained. Hence, watch from the beginning till the end. And next request is, please do have a notebook and a pen with you, because various questions which have been asked in Evidence Act in various exams would be mentioned or would be stated. And in addition to this, idea would be given as to how questions could be framed in a particular section. It is very important for you. So you all need to make a note of all these aspects. And in addition to this, some additional illustrations would also be given while teaching the act. Hence, you please make a note of all those additional illustrations as well. They would be of absolute help to you in understanding the particular section. And in addition to this, various ways or techniques would be taught which would help you to remember those sections, or to say some memory techniques would be given. This would be really helpful to you in remembering the sections when you go to the exam. I hope this video would be of absolute and great utility to you. Section 157. Former statements of witness may be proved to corroborate later testimony as to same fact. Imagine a situation where there is a witness standing in the witness box in a court. He has said about a particular fact prior to coming to the court somewhere else, maybe to the authority or at some other place or the place where the incident took place. In all these situations, those statements can be brought before the court to prove what he has stated inside the court. Let us try to understand this particular section with our own created example. Imagine robbery took place in a street. At that time, there is a person who is standing there waiting for his friend. He is seeing the robbery happening before his eyes. In that case, he goes to the police station and says that, sir, a robbery took place, I saw this and I'd like to be a witness. And he narrates as to how that particular robbery happened. When that being so, his witness is being recorded, then subsequently case is filed, then he is called to the court for deposing his witness. At that time, we can prove the statement of that person which was given to the police authority. Once we prove that, we can corroborate that particular witness or the statement with his later testimony which he gives in the court. This would be helpful to prove a case. This is what is explained in section 157. Section 158. What matters may be proved in connection with proved statement relevant under section 32 or 33. This particular section, we need to split this section into three parts. Then we can easily understand this particular section. So if there is any statement which is considered to be relevant under section 32 or 33, already we have made videos with respect to section 32 as well as 33. All those videos would be given as a link in the iCard. If you have not seen those videos, please do go and watch these videos, which would really be helpful in understanding this section, that is section 158. So if something is proved to be relevant or some statement is considered to be relevant under section 32 or 33 and that is proved, then all the matters may be proved to contradict that particular statement or to corroborate it. Either you can produce some evidence to contradict that particular statement, or you can produce evidence to corroborate that particular statement, or you can try to impeach the credit of a witness who gave that statement, or you can confirm the credit of the witness by giving an evidence. For example, if there is a person who cannot be found, he has already given a statement and that statement has been proved. In that case, we can prove to the court that this particular person who gave that witness, if he was available and if he would have been brought to the court and he has denied upon cross-examination the truth of the matter suggested. In that case, this can also be proved in the court. That is what section 158 states. Now let us move to section 159, refreshing memory. There are practically two aspects in this. Now, there is a witness who is in the box. He has given something in writing some years back. Now, that particular aspect is in question, or that is a question which is raised, which needs to be answered by the court. In that case, this person can be permitted to see that as to what he wrote, because it happened so many years ago. So if the court is convinced that at that time it would have been fresh in his memory, but now there is a good chance that he might have forgotten it, or he needs to refresh what he stated. So in that case, the court can permit him to see what he gave in writing some time back. And in addition to this, the court may also permit a person to refer any such writing made by any other person, which was read by the witness within that particular time. If he is going to read that, he can say whether that is a correct statement or not, or correct aspect which is being written or not. Now, when the witness may use copy of a document refreshes memory. Generally, you all know, when a document is marked, generally original documents are marked, but there are certain situations where a copy of the document can also be marked. So now the witness is saying, I need to refresh my memory with a copy of a document. So in that case, what we should do, that particular procedure is provided here. With the permission of a court, a witness can refresh his memory with a copy of a document. However, the necessary condition is that he should give the reason why he has not produced the original. He should give sufficient reason. And an expert can be permitted to refresh his memory by reference to professional treatise. That is permitted. This may also be asked as a question in the judicial exams. So please make a note. An expert can be permitted to refresh his memory by referring to the professional treatise. Now let us move to section 160. Testimony to facts stated in document mentioned in section 159. Imagine there is a particular fact which is stated in a document. Then I am going to the court as a witness and I am saying what is stated in that document or the fact mentioned in the document is true. But I don't exactly recollect all the facts. But I know one thing for sure, that the document which has been showed or the document which contains the facts is properly recorded or is correctly recorded. Now let us try to understand this by way of the illustration which is provided. Generally, business people have a person called as bookkeeper. He will maintain all the transactions. He will write all these transactions in a book and maintain that book. Now, this person who was a bookkeeper comes to the court as a witness. He is saying that I remember that I used to write all the business transactions which took place on a particular day. I record it in a proper fashion. I always put record along with dates and time and other course or the business related transactions. Now, he knows the fact that the books were correctly kept, but he has actually forgotten particular transactions entered. Even in that case, this bookkeeper can come as a witness and depose certain aspects, and it is permitted by law. Now let us move to the next section, 161. Right of adverse party as to writing used to refresh memory. Now, imagine there is a witness standing in the box. He is seeing a document and refreshing his memory. In that case, the opposite party will ask, sir, I don't know, what is the document which you refer to for refreshing your memory? So I also need to know what is the document you referred. So in that case, the opposite party should also be given an opportunity, and he should be also given an opportunity to cross-examine the witness with respect to that particular document which he used for refreshing his memory. I hope you would have liked the video. If you like the video, Please do press the thumbs up button and do share the video with your friends and motivate them. If you are not subscribed the channel, please do subscribe the channel and share the channel with your friends. If you feel that I've left something in this video or you want me to change the way in explanations are given for the sections, please do let me know by way of comments. Let us join hands together and contribute for a learned society. Thank you.